on all of the NESA platforms. Start with an apology for starting late. Unfortunately, we had a matter that we needed to deal with, and we truly apologize for that. But we'd like to welcome all of the members of the public to the ELS meeting number 211 of the 5th of September 2023. The meeting was scheduled to start at 9. It is now 10. But it's scheduled to run until 12. It's a fairly lengthy agenda, so we'll try to be expedient, but without compromising the quality of the discussion by members. I'd like to welcome you all. The agenda today, as published, has got a few items from item number 3, from item number 5 to item number 16, which was supposed to be dealt with in an open meeting. But we'd like to indicate that at a pre-meeting or the discussion that we've just had, there's been a request that we withdraw item number 8, which is the Envusa Energy Pty Limited application for the trading license, because that application is incomplete, and that it will then be brought before the energy regulator when it's ready for consideration by the members of the electricity subcommittee. With that, members, can I see by show of hands if we can adopt the agenda with that removal of item 8? Thank you, Advocate Sithole, Madam Massetti, Spear, Mr. Mkhize. I also support Mr. Pokula. Are you happy with the adoption? Thank you, Mr. Pokula. Having adopted the meeting, the agenda, members, I'm not sure if there are any verbal declaration that members may want to make in respect of the items that are going to be discussed today, the matters that are on the agenda formally. If by show of hands, members, if anybody, Mr. Pokula.
Thank you, Chair. I was going to declare, I think, before this item was removed, but I do want to clarify my declaration of interest. It is a matter of principle. By the Act, I have no pecuniary interest in Envusa, but because I would not want any of the, I would not want the perception that any decisions that are either for or against the competition, I was party to that, then I make it a principle that I do not participate in the decision making for any of the entities of the traders. So I do want to put that on record that I'm not conflicted, and there's no requirement by the Act of my pecuniary conflict or interest in this, but as a principle and to make NESA's decisions not to ever be queried, I was going to state that as I was going to withdraw and also state it as an item I wouldn't want to participate in. Thank you, Chair.
Thank you, Mr. Pokula. Will that also apply to agenda item number 9, Mr. Pokula? Application for a trading license by the NTCSA?
Yes, Chair, it will. So it was 9 and the other one. Sorry.
8 and 9. Okay, yeah. Okay, thanks.
Thank you.
Mr. Pokula, can I then, I think formally also then indicate that in terms of our processes, we always indicate that you can excuse yourself from making decisions, but we would like to, and I think formally I'd like to raise this formally to indicate that because you bring that particular experience as well in respect of this particular sector, that it would be useful that if you can participate in the discussion itself, not so much in the decision that's going to be made, if possible, we would really appreciate your participation on item 9 as well. Thank you. Members, any other declaration? If none, can I ask that the members of the ER and also the members of staff, if you can complete the forms that are published and actually send them through to Mr. Mabunda. With that, members, can we then go through? Can we go straight to agenda item number 5, Mr. Mavuso? Agenda item number 5.
Chair, this will be presented by Tamai, but I just want to say, Chair, this matter involves tariff reduction and subsequent amendment of the generation license. And just this particular one, Chair, was licensed during the bid window 2 in 2012. At the time, in terms of because the
We lost you there, Mr. Mavuso. Mr. Hore or Mr. Jacobs, please assist.
If I may come in.
Yes, please do. Yes,
okay, thank you very much.
And don't forget to talk to the issues that were raised by advocate, please. Thanks.
Yes, I'll just take over from where he left. It's a bid window 2, and it also participated in the refinancing protocol, which by now it's a well-versed project where the lender, where the project themselves, because the projects have de-risked, the IPPs can go and have refinancing where they get a cheaper debt, as well as releasing some of the debt service reserve accounts and maintenance reserve account. As on the page 20 of the RFD, it just shows the characteristics of this refinancing. And after negotiating with the department, then they agreed on the tariff reduction as stated in the submission. I wanted to highlight a correction on paragraph 8 of the submission itself. There was a typo error there. The percentage reduction there, as you see it, it's not correct. The correct percentage reduction is actually on paragraph 21 of the RFD, just for the record purposes. Or better still, that value that is on paragraph 8, you can just minus 1 percentage point to give you the correct value. But otherwise, all the figures, as stated in our recommendation, both on the submission on paragraph 14, page number 4 of the stamped page, they are correct as they are. And Chair, I would like to request that you approve the recommendation that are on the draft decision, page 10, the stamped page 10 on the draft decision, both the first recommendation and the second recommendation to include the reduced tariff in the power purchase agreement. Thank you, Chair.
Thank you, Mr. Hore. Members, we've got a submission before you. Any comments, questions? Doesn't seem like there are any questions. Mr. Mkiza?
No, I support the recommendation, Chairperson. Just one thing. Are these figures supposed to be deducted?
Okay. That's the first question. And also, can I then recognize Madam Spear?
Thank you, Chair. Good morning. For me, it's just a technical issue with regards to refinancing, because obviously you do talk about the extension of the repayment term. So obviously that is not the reduction of the cost that was originally there, because the original tariff is based on the original cost as is. So I just wanted to ask a question with regards to the application. This applies with effect from the date of approval, and it's not backdated, because decisions technically can't be backdated. So it applies from now going forward. Will it not be a disadvantage then to the company based on the previous period? Thank you.
Thank you, Madam Spear. Mr. Hore, if we can respond to both questions.
Okay, thank you very much. With regards to Mr. Mkize's question, yes, these figures are confidential. That's why they are redacted. You would find that the application itself, it's purely based on the financial information, including the financial model, which was already ruled to be confidential by the energy regulator. And the other thing is that this refinancing project, the IPPs themselves are still coming in, and the tariffs are not actually being divulged. With regards to Mrs. Spear's question, yes, it will take effect from the date of approval or at the signature date after we had approved. There is a clause, if you look at our decision number 1, that allows them for market conditions at refinancing financial clause where the approved tariff is applied for. It doesn't have to affect the plus or minus 20%, just to take into consideration all those other changes in the for example, the interest rates, the exchange rates, and so forth, and the increase or the increase in the payback period, it's to the advantage of the shareholders, since they will now be able to use less money to service their debt, but in exchange of servicing their debt on a longer period. And normally, this one we find that the lenders they want this, or they prefer this once the project have de-risked, so the shareholders will have more disposable money in their pockets at an earlier stage than waiting to only get more money at the end of the project. Thank you, Chair.
Thank you, Mr. Hore. Any additional questions, members? I'm assuming that your questions were fully answered. Advocate Sithole?
Chair, it's not a question, just to confirm that the correction that Mr. Hore made in his presentation at the beginning, it covers me very well. Thank you.
Thank you, Advocate. So members, you've got the presentation before you. Can I then move us to a decision that is sought? It's actually on paragraph 14, but I think it's better to read to consider the actual decision that is on the overstamp page 10, just to be on the safe side. But it is the same. So members, by show of hands, can we approve? By show of hands, members. Thank you, Mr. Nkize, Advocate Sithole, Madam Maseti, Ms. Sabia. I also support the approval. Mr. Pokula, I'm just missing you. But you've got your decision, Mr. Hore. If we can then move on to the next item, item number 6. Back to you.
Thank you, Chair. I'll also take this as read. It's very similar to the one that we have discussed. But on this one, I just wanted to make one correction on paragraph 21 of the RFD, just for record purposes. The percentage reduction there, it's actually 1 percentage basis more than what is reflected on paragraph 21. I think there was a mix-up between this one and the previous one. You will find that the previous one, it was actually 1% basis less. This one is actually 1% basis more. But the figures themselves is on the decision that you are seeking on page 10, that is stamped. Those are correct. And if you do the calculations, they will find that you arrive at the correct percentage reduction. And with that, we request the energy regulator to approve as recommended on paragraph 1 and paragraph 2 on page 10. Thank you, Chair.
Thank you, Mr. Hore. Members, any comments again, questions? With the change that has been proposed, has been indicated on that paragraph 20, 21. Doesn't seem, I guess it's similar to the first approval sought, Mr. Hore. Members, can I then take you to the decision that is sought? Again, it comes out of paragraph 14 of the submission, similar to the decision that is on page 10, the overstamp page 10. So members, by show of hands, if we can approve that. Thank you, Madam Maseti. Thank you, Ms. Spear, Mr. Mkize, Mr. Pukula, and Advocate Sitola. I also support Mr. Horo. You've got your decision. Can we step off this one and go to item number 7? Is it still your matter? Mr.
Yes,
Horo?
Chair.
Okay, please
Yes,
proceed.
Chair. On this submission, this is the request to recommend to the energy regulator for approval or to note the risk allocation of ESCOM standard offer power purchase agreement and ESCOM's emergency power procurement program as per the delegation matrix. You would recall that during the multi-year price determination, MIPD5, the energy regulator approved these 2 programs for standard offer program and the emergency power procurement program with the financial cost for the 2024 and 2025 financial year have been approved as per table 1 on page 3, that is overstamped. But the application itself in the MYPD5 application, ESCOM had actually applied for these programs to go up to 2028. But the energy regulator have already made a decision in the MYPD5 that we cannot approve this for the 25-26 financial years up to 27-28 financial years, but rather ESCOM should apply for these costs in the relevant MYPD6 application. Subsequent to that, the energy regulator confirmed cost recovery mechanism for the 2 financial years, 2024 and 2025. Now, ESCOM in this application, when it submitted the application for to note the standard offer PPA and the risk allocation in the PPA, as well as the emergency offer PPA and risk allocation in the PPA, it also requested the energy regulator to reconsider the decision and allow or approve the cost recovery mechanism up to 2028. The Annexures A and Annexures B shows the risk allocation of this power purchase agreement, and generally it shows that there is a fair risk allocation between the buyers and the sellers. The risk allocation and analysis of the PPA is being done in accordance with the MYPD 4 methodology and the cost recovery mechanism that says the buyer would present its capacity, energy requirements, and cost to NESA, and NESA would review the plans and allow or disallow cost. But that one was already done during MYPD4. So what we are asking, the recommendations on page 5, based on the narrative that I've already said, is to 14.11 to note the standard offer PPA and the risk allocation in this PPA, and 14.1.2 to note the emergency offer PPA and risk allocation in this PPA, and on 14.13 not to confirm the cost recovery of these programs beyond the approved MYPD 5. There's just a correction there, MYPD 5, but commit that ESCOM may include this cost in the MYPD 6 application for the energy regulator decision, because this is what is in line with what was already decided by the energy regulator. Thank you, Chair.
Thank you, Mr. Hora. Members, we've got a submission before us. What say ye? Questions, comments? Mr. Mkiza?
Thanks, Chairperson. Thanks, Mr. Hora, for the presentation. Under 4.4, I think it should be programs and not necessarily projects, because there aren't projects that are listed there under table 1. So if you can just indicate that. And I think it's also important to put the third element, which is the consumer. Because if you're talking of risk allocation, we can find a situation where the risk is actually shifted to the consumer, but the buyer and seller are left with no risk, or not necessarily no risk, are indifferent in terms of the standard offer that is on the table. So it's important to note that. And I take it that these are standard documents that have got improvements from time to time. I think it's going to be important to also indicate if there are any areas of improvement that have been made in the documents as we move from year to year. That will be all from my side in terms of the comments, but I do support. Thank you.
Thank you, Mr. Mkhize. Any other questions, comments, members? If not, Mr. Horo, if you can assist.
Thank you very much. I think those was for enhancement. And I'll factor that. Then when it goes to the energy regulator, those elements will be included. Thank you, Chair.
Thank you, Mr. Horo. Oh, by the way, these are for recommendations. Yes, it is recommended that we recommend to the ER. Thank you, members. With those enhancements that have been noted and will be effected, can we then make the decision by show of hands, members? Looking at paragraph 14, can we approve paragraph 14? Thank you, Mr. Mkhize, Mr. Pokula, Madam Maseti, Mr. Spear, and Advocate Sitore. Mr. Horo, you've got your decision. That's item number 7. Item number 8 has been withdrawn, as indicated, that this application is still should not have come before the ER, should not have come before the energy regulator or the ELS for a decision. It's an incomplete application. It still needs to be completed to meet the minimum information requirement. So if we can then step off that one and then go to item number 9. Mr. Mavuso, I hope you...
Yes.
Yes. Okay. Please introduce this and talk to whatever the issues, including this updated document, to please indicate what it talks to yourself and the team. Thanks.
Thanks, Chair. Just Chair, to apologize, I was cut and I didn't expect this because I have full backup. So sorry, apologies for that. Chair, I think maybe let me start by saying that this license application has been with us since 2022 September. And it was part of the bundled applications where there was also the main company, the NTC, to go together with export and imports. And we had decided, Chair, that we needed to really deal with certain things that we were not clear about in terms of the two ones, which is the trading and the import and import and exports. And Chair, the only issue here that is really, what can I say, needs to be ventilated is the one of the single buyer. And including at the time when we had a public hearing, there were no real objections, in terms of the whole application, except SALGA, who have advocated that they need the distributors need to have access to the transmission infrastructure. So that's the main issue that probably we will have to make a decision on. Other than that, Chair, I'll give it to Spear to ventilate some of the issues that we've been dealing with. And I have to say, Chair, also, this application really stretched our understanding of the industry because of the advent nature of this application. Thank you very much. Spear, can you please help?
Thank you. Thank you, Chairperson, and good morning to you and the members. To start with my presentation, Chairperson, I must add that, yes, the application was evaluated and it met the requirements of Section 10 of the Act, and it also followed the public participation process as per Section 11. And then, Chairperson, the issues that I would like to highlight, I will start with the one of the single buyer, where within ESCOM, And then NTC wanted this single buyer to be seeded so that they can take over being the buyer of the energy that is being bought from the DMRE IPP procurement. This process was done, Chairperson, in terms of that the minister on the 6th of June wrote a letter to NERSA requesting NERSA to concur that the buyer reassignment be taken to NTC. However, the issue at hand here is that NTC wanted to be the exclusive buyer of the energy from the IPP procurement program, of which we have stated in our draft license conditions that it is only the minister that can determine who the buyer of the energy will be and for future projects. And we, as NERSA, it is not our space to say, yes, you will be the buyer for future IPP procurement. And then the issue of the discrimination, where SALGA raised the issue that they want also to be the buyers of electricity at transmission level, since this trader will be using the transmission network to sell and buy energy. This issue was addressed in our draft license application, license conditions, where we stated that any person can buy the energy at the transmission level and they should not be discriminated. Chairperson, without wasting time, I will go to the recommendations on PE on page 10, where we are recommending to the ER to approve the 2 recommendations. Thank you.
And I was kind of hoping that you guys, Mr. Mavuso, you're going to talk. You submitted something late yesterday, and that amendment. I was hoping that you're going to talk to that. What has changed? I guess what was included there, because you've updated the draft the draft RFD, for instance. So I was kind of hoping that you bring members into your confidence in terms of the high level. What are the issues that may have been changed, including as you said, the annexed charts that may have been updated. I think it's only fair before we open it up to members.
Okay, Chairperson, I'll take that one. When you look at the uploaded document on item 9, the RFD was not included, and I merely requested the RSU to upload the RFD that was missing, and we didn't update any information per se. Thank you.
All right. Okay. And the 2 are aligned. So, for instance, the number of years that are for the license that is contained in the RFD, is it a similar recommendation that is contained in the submission itself?
On the submission, Chairperson, there was a recommendation that was made by the members when we had the internal workshop, where we were guided that the license term should be 20 years and it should align with the power purchase agreements of the DMIPP bidding projects. However, since this is a transitional arrangement where NTC is still going to draft agreements and formalize them, and also apply for a tariff that has to do with this trading process, we have proposed that, at least since this is a transitional arrangement, we propose that the license be for 2 years, and after Eskom has applied for a tariff in line with the methodology that NERSA is currently adopting, it is then that we can extend the license when they come for an amendment to 15 or to 20 years, and also come with formalized agreements. Thank you.
Thank you, Mr. Kumalo. Members, you've got the submission before you. I think it's the challenge with this also is that it comes at a time when the the Electricity Regulation Act Amendment Bill is still before Parliament. It actually has not even been debated by Parliament, and that brings marked changes. So whatever that the team had to contend with was to look at what the existing law allows. For instance, the single buyer is not a licensable activity, or what is called the central purchasing function is not a licensable activity at this stage, but in respect what is proposed in the amendment bill that it will be. And also the issue of the TSO is better explained in the amendment bill, including what the TSO may possibly do, become a market operator in the future. Those issues are better explained in the Amendment Act, and therefore this decision that is being made or being asked to be made, recommended to ER, is one that is made in an environment which is changing, and hence the view that we needed to look at this more as a transition. We needed as the members to consider that whatever that we do, we see it as more a transitional arrangement, which can be amended at any time, of course, and hence the proposal not to consider 15 or 20 years as what the bill might, or as what the existing act might propose, but rather to look at it and say, we can be granted for 2 years and or between 2 or 5 years, or whatever the number that the members may recommend to ER, with the view that further amendments will then be to the license will then be applied for as the environment becomes clearer and clearer with the adoption of the Electricity Regulation Act, and also all of the other issues that are still in transition that we are looking at, including the actual unbundling process itself, once it's fully done. So once it's quite clear the role that's going to be played by the different parts of the then ESCOM. Once those are clear, then we'll then be able to then revisit this application and then extend it. So members, I just thought I would add that. Thanks, Mr. Kumalo, for the presentation. Can I then open it up to you, members? You've guided before at workshops, but this is an opportunity now to provide guidance in an open platform. And I don't think that Mr. Pukula cannot participate in the conversations, perhaps might not necessarily participate in the decision, not because he's got pecuniary interest, but as he has indicated that because it's a trading license, that it might be best for NERSA that he doesn't actually participate in the decision-making itself. But I think he can still guide in terms of the conversation. But over to you, members, for your comments and questions. Starting with yourself, Advocate Sithole.
Thank you, Chairperson, and thanks to Mr. Kumalo for the presentation. Chair, I just wanted to get clarity on the issue of the term of the license, because if one looks at the draft license that is in the pack, it stated that the license will be for 5 years. And it says that it will commence from date of issue and be enforced for the period of 5 years. But in his verbal presentation, he mentioned 2 years. And I understand that based on what the members recommended at the workshop, 20 years, they had to look into that and come up with the proposal of the term as he has presented. But I just wanted to get clarity whether maybe it's a mistake in terms of saying 2 years, and yet the draft license in the submission, it says 5 years. And again, Chairperson, I would have thought that maybe the 5 years may be appropriate if one looks at the current draft electricity regulation amendment bill. It does say that it does seem to indicate that the NTC, it's a transitional structure, as he has mentioned. However, it will be pending the incorporation of the national systems operator, because if you look at the functions mentioned there, I think it's section 34, capital A. want to, whatever, that whole proposed amendment in there seems to indicate that the national systems operator should be established within 5 years. So I thought that we may, or the team would be proposing the 5 years as I've seen it in the license to probably have been aligned to what's contained in that section 34A. However, I'm just getting a bit confused with the 2 years. If they can assist me to clarify that for me, I'll appreciate it. Thank you, Chairperson.
Thank you, Advocate Sithole. Mr. Mkiza, your hand has gone down.
Thanks, Chairperson, and thanks to the President. I'm partly covered by what Advocate Sithole has said, and also to say that maybe we also need to look at the legality of that, so that it's based on a firm legal base, because you could have a situation where it is issued based on what is required by law and then have reopeners instead. And the other thing that I just would like to get to understand is the time it has taken to get to this stage in terms of the finality. I would appreciate if that can be accounted for clearly in the submission itself. Thank you.
Thank you, Mr. Mkiza. Any other? Madam Maseti?
Thank you, Chairperson. Chairperson, I just want to check the importance of paragraph. I think it's on this paragraph 4.8 on this submission. It relates to, we are told about the date of application for the trading license, yet here this submission relates to an application for exports and imports and exports at SAP. So it's very confusing. It just comes in there and then it follows. It is followed immediately in paragraph 4.9 by the date of publication of the application. So there may be a mistake there, because I would have expected that we state the date on which the application was filed with NERSA, this specific application that is for imports and exports. Thank you.
Thank you, Madam Maseti. Any other question, members? Comments? Okay. Before you do, I think sometimes it's confusing. I know Mr. Mavuso introduced this as the application was made in September 2022, but in fact, they only, as Madam Maseti is indicating, that they're only published in terms of Section 11, as indicated in paragraph 4.8 of the submission. So it's confusing. Which is which? Well, I think if we can clarify that, and I think it also talks to the question that is asked by Mr. Mkize, his second question, which you need to account for time taken. When was this application deemed to have been to have met the minimum requirements, and therefore formally adopted? When did the 120 days start? Did it start in September last year? Did it start in March 20 of this year? Please just clarify that. Thanks. Back to you, team. Mr. Kumar, if you can address the questions.
Okay, thank you, Chairperson. The question from the CEO regarding the term of the license. Yes, initially our proposal was that it should be 5 years. However, the 2 years is where we are requesting it should be. We are proposing that it should be 2 years, but at the same time, from the guidance that we can obtain from the members, that it might be 5 years. I mean, this one, it's open for guidance from the members. And then the issue of the license, when did we receive the applications? and which one is the actual date of counting the 120 days. Yes, we did receive the applications, the 3 separate applications on the 28th of September last year. And then after receiving the applications, we held several meetings with ESCOM regarding the information that they've provided in the application itself. But most of the time that was taken in our engagements with ESCOM, it was about the buyer reassignment, where they wanted to transfer all the PPAs into this trader without the approval of the minister of the DMRE, which is the custodian of those Section 34 IPPs. So most of the discussions that took place, it was based on that, where we had to also hold meetings with DMRE regarding this issue of the buyer reassignment, because at first ESCOM wanted to transfer the PPAs, and they were advised that legally they need to cede those PPAs to NTCA, but that should be after the DMRE has approved the buyer reassignment. And then after that, January, it's then that we requested ESCOM to advertise to provide us with the redacted applications so that we can take them to our internal process for approval before they can be posted on our website. And the same redacted applications were the ones that they were going to use when they are applying, when they advertise their projects, informing their stakeholders about the applications that they've submitted to NERSA. Thereafter, the public consultation took place, where they published their applications on the 19th of February, and we also published our notice as well on the 20th of March for 30 days. And after that, a public hearing was held. And then that's where ESCOM provided further information to support their application, given the questions that were asked during the public hearing. And then after receiving that information, it was then that we said the application is final, and then we can process it so that members can decide on it. I don't know whether my other team members would like to add on what I've said. Thank you.
Okay, members, can I guide further on this one? So firstly, just in respect of the question asked by the CEO around the national systems operator. The license that was granted to the NTCSA already is actually a transmission and systems operator, because that's what was applied for. So in fact, when the amendment bill comes through, that license is now actually the systems operator function, which at this stage, systems operation is non-licensable at this stage. However, it was applied for as part of the transmission license, and that was incorporated in the approved system. So that has actually been dealt with. I guess because it was applied for, although it's non-licensable at this stage, but it was applied for, and there's a link between operating the transmission system as well as operating the actual system itself. So that's why it was granted as a TSO. So that has been dealt with. But I think the challenge here, and I guess I see Mr. Khumalo has dealt a lot with the single buyer, but the single buyer status is not licensable at this stage. And issues that are peculiar to that central purchasing function, the reason why there's a move even from the word single buyer to a central purchasing function is that it does say it does recognize that the buying function would not just be limited to ESCOM Holdings or rather to NTCSA, but the buying function can actually be done by other licensed distributors. So it's just that this one is going to be the central purchasing function that will need to be dealt with by the TSO, by NTCSA. But it's not a licensable activity at this stage. But there were issues that are peculiar to it. But the trading license, which is what this application is about, is what was of concern. And the issue here, and as if you go through what the team and also the guidance that was provided by members, the non-exclusivity, that Eskom had applied for an exclusivity in terms of them buying all the power from all of Eskom's plants, as well as all of the reprograms, basically coming out of the reprogram, buying all of that power, and also specifically only selling to Eskom distribution. That's what NTCSA applied for. Now, unfortunately, in terms of the analysis and also from the guidance from members, is that exclusivity, unfortunately, could not be supported. But unfortunately, that raises a lot of challenges because that is not how the system is currently operating. Hence, the need to say, yes, you can have the trading license and be a trader. But in the interim, hence the actual recommendation for 2 years, that in the interim, why don't we, as we are transitioning, also this new act that's coming and bringing its own challenges and new ways of work as it's being put through the parliamentary processes and whatever. And also, as we are transitioning in terms of this unbundling process, better understanding of this unbundling process, could we then retain what was applied for? But only for the 2 years. That says, and it is seen as a transitional arrangement. It's not trying to actually exclude everybody for the longest of time, but to allow 2 years to transition out of this exclusive arrangement. Hence the 2 years that has been applied for. Members could maybe think that perhaps Eskom may need 5 years. That, I think, it's something that will be put to members for a vote. But the point is, we need to understand that it's actually in respect of the exclusivity. That is of concern. That in terms of how that talks to the objects of the Electricity Regulation Act, perhaps it cannot be supported, but it is a reality at the moment. And that's what NTCSA had applied for. Hence the need for a transitional arrangement, hence the 2 years. I'm hoping I have explained that, members. That is the challenge. And also, in terms of the time, by the way, is that all of these licenses, all 3 licenses were applied for at the same time. And there was a lot of toing and froing. Same as this Invusa license that we've just decided to withdraw, is that there was a lot of toing and froing, perhaps not necessarily in respect of these licenses in particular, but on the side issues like indicated in terms of the single buyer status, that then delayed the licenses from being deemed to be complete and then ready for them to be processed. That was the issue. And then, of course, subsequently, the issue was, do you then not consider and have the main application, because the Act is quite clear that you need to actually separate transmission, operation of a system versus the trading. So that was the issue, and hence them being handled in a sequential manner. I see there are follow-ups, starting with Advocate Zetor.
Thank you very much, Chairperson, and also to Mr. Khumalo once more. Chair, I've just heard what we have said, and in terms of the NTC being a transitional structure. And as I said, if you look at the draft amendment bill, it then says that those functions that are currently being undertaken or licensed, that we have licensed for, including systems operator, which is not yet licensable, or the functions are not yet licensable, are going to be taken over by the national systems operator. And if you look at the draft amendment bill, it talks about the national systems operator possibly being formed within a period of 5 years. And hence the proposal for the period of 5 years in the license that's there. But maybe for me, I'm not really clear in terms of understanding why would the recommendation be 2 years. And if, again, I have listened to Mr. Khumalo in his presentation, he did say that the issue of exclusivity has been addressed. And he said that it has been addressed by saying that this is something that would have to be determined by the minister. So I thought that some of the issues that were said to be a challenging single buyer exclusivity have been addressed in terms of this particular application. And the only thing for me is to understand why can't we link up the transitional period to what is being proposed in the amendment bill? Because as we know, drafting an act, it's a lengthy process. And it may not happen, like in a year, or it may happen in a year. But to be on the safer side, I thought it would be better for us to really align ourselves with what is being proposed in the amendment bill, such that we do not have to really come back and revisit this particular application again. So that was just my proposal, which I'm saying it's linked to what is in the draft amendment bill, and as well as the fact that the issues that were said were of a challenge, the team have managed to deal with them. So therefore, then I do not see why we cannot amend the period or issue the license rather to be for a period of 5 years. Thank you, Chair.
Thank you, Advocacy Holder, Mr. Mkhize.
Thanks, Chairperson, and thanks for the responses. I'd ask the issues of the legality, if there are any, concerning the period, because as indicated, I would rather go for the 5 year and then have reopeners, because the period is not just there because you like a particular number. It's informed by the expected evolution of this industry based on the pieces of legislation that needs to go through the processes of the approval processes, and hence there should be a link to that, and a longer period with a reopener if these unfold earlier than expected I will actually prefer that. And also it's very important to then be clear, because when I read 4.17, I think maybe it's not the updated part, but the 4.17 which talk to the issues of discrimination, issues of exclusivity. I think it should be written in a clear way as to saying what stance do we take, because as you've said, there's issue of orderly development. There's an issue of saying the as-is situation vis-a-vis the to-be. If we're looking at the transition, you need to then consider the issue of orderly development and maybe allowing certain things for a short period of time so that we can then stabilize and have orderly development. Hence, there could be situations where this exclusivity is allowed under that dispensation. So I think, but it should be clearly articulated and also to what it pertains to. And with that, from my side, I wouldn't really have a problem, but just putting a time is informed by certain things, and therefore let's make sure that we are clear with that. Thank you.
Thank you, Mr. Mkhize. I'm not sure if there are any comments. Can I, Madam Massetti, before I give it back to the team, I thought I would add something. Madam Massetti?
Thank you, Chairperson. Chairperson, I would like to indicate that whatever period we agree to, which at this stage, because of the other uncertainties and other processes, one of them being the bill that is still before Parliament, we will have to consider a shorter period or duration for the license. So that is the first proposal that I'm making. If there are other uncertainties, and we must specify what those uncertainties are, one of them being the amendments and this transformation that is taking place and the other things. So that is the one uncertainty. So on that reason, we can then try to limit the duration of the license instead of 5 years, or we can then say 2 or 3 years, whatever the reasonable period is that will enable within that period those things that we are uncertain about to unfold and take place. So the duration must be motivated by the specific activities and other uncertainties that must take place within that period. So that's how, Chairperson, we should deal with the issue of the duration. When it comes to the issue of exclusivity must always come with certain obligations. It is not just a free card that must be granted. So especially by the regulator. So the regulator on the issue of exclusivity, the first thing that we must be clarified is why exclusivity is necessary. What necessitates the exclusivity? So that question must be answered clearly. Then secondly, whether what is being the arguments or justifications that are advanced can only be achieved by way of exclusivity. That motivation must come very clearly. And for purpose of the regulator, it will have to be motivated on the basis of economic benefits or any efficiencies that are claimed by the applicant. It is not just something that the energy regulator must think on its own what the efficiencies are if we're to grant exclusivity, but the applicant must motivate the reasons for exclusivity, and those reasons must be reasons that talk to efficiency gains that can be that can arise out of exclusivity, which will enable the licensee to do these other things with the benefit of being an exclusive license for the activity. So that will be my contribution, Chairperson. I'm not aware of any other way we can actually grant exclusivity without stating first the obligations, also the necessity and the efficiency gains. Thank you, Chair.
Thank you, Madam Massetti. By the way, Mr. Jacobs, Mr. Hore, please don't just let Mr. Khumalo to answer these questions on his own. There are lots of team members here. But before I give it to you guys to respond, can I just clarify a few things? I think there may be confusions, maybe in terms of how we communicate. Firstly, the NTCSA Transmission Systems Operator License has been granted and it is valid for 25 years. So the NSO, as the National Systems Operator, that may be envisaged as the additional function that becomes licensable. What we are saying, that has already been applied for in respect of the existing law, and there was no reason why it would not have been granted as part of the TSO. So, and therefore that is already been granted for 25 years. So that is the first one. I think, and we would like to separate the two. The TSO license is different to what we're discussing today. What we're discussing today is a trading license. So all of the questions and the issues that are being raised are in respect of the trading license, not in respect of the TSO license, which is valid for 25 years. So I'm hoping that is clear. So the transitional NTCSA is not a transitional structure. NTCSA, it may be a transitional part of it could well be the fact that it is still under ESCOM holdings. In the future, it may be under, the shares may be held by a different structure. But at the stage, in respect of the unbundling process, it is still part of the ESCOM holdings. So the NTCSA as a structure, it is not a transitional structure. So I think it's important that I clarify that. Now, the issues again, which are being dealt with about exclusivity, I tried to raise this. It's the thing that Mr. Khumalo was talking to, and he can explain this himself. The exclusivity in respect of the single buyer function. That is what he was talking to as being the space of the minister. that only minister may, in terms of Section 34, may determine who the buyer is. It's not something that can be applied for. In terms of the single buyer status, but as indicated, at this stage, at any rate, the central purchasing function or the single buyer function is not a licensable function. So yes, it may have been included in the application, but it was a nice to know, but it's not a licensable function. It's not something that the regulator could pronounce on. So that's the one other issue that I wanted to indicate. The transition that is being discussed, the transitional arrangement, is one where we then say, Eskom had expired. Can we take the single buyer thing and put it on the side? But it had applied to have an exclusive right to buy all the power coming out of Eskom plants, and also to exclusively only sell to Eskom distribution. Something that has been indicated in the past, as objected to by SALGA, but has also been in terms of the engagement by the members and as indicated by Badama Seti as well, that exclusivity unfortunately may not be supported by the Act. And therefore it needed to be applied for, and the reasons, condition, and if granted with conditions, and that it must be clearly indicated as necessary. But in engagements with the applicant, it became clear that unfortunately, if this exclusivity is not granted, that the exclusivity of buying all the power from Eskom and only selling to Eskom distribution, if that is not granted, it brings a lot of risks to Eskom holdings in the environment that is currently. Firstly, the Act is changing. There's going to be a market that's going to emerge, but that's the future. We unfortunately can only grant licenses in respect of the current law. So once the market operator function is given to the TSO again, it definitely has to be an independent player. It can't be a trader, for instance, or maybe it might be a trader, but a different type of trader. We don't know that, what would be specified once that bill is adopted. That's number one. Number two, there's this unbundling process. Itself brings a lot of challenges. Number three, the actual pricing review that is currently underway. So those are the issues that are then saying there are lots of uncertainties, but we're not suggesting necessarily that therefore the exclusivity can just be granted, but in understanding that we need to all understand the transition from what we have, because at the moment, all of everybody buys from Eskom distribution, right? Now, that's the current status. Now, because of that, we need to have a transitional period. Should that transition be 5 years? Should the transition be 2 years? So that's the transition that is being spoken about. But the team will actually add to that. Now, in respect of the period, I have to take members to Section 20, subsection 2 of Electricity Regulation Act. Whilst for the operations of generation, transmission, and distribution, the period is specified there as 15 years or longer. But actually, even distribution, both distribution and trading, when you look at Section sub 20 subsection 2, it just says the license can be issued, is valid for a period determined by the regulator. So it is not prescribed. So that's the legality, Mr. Mkiza, that we're asking for. So if I can hand it back to the team, I just thought I would actually explain those, and maybe another 5 minutes or so, colleagues, on this matter. But if I can hand it back to the team and also maybe ask legal to also comment. Mr. Hori, I see your hand is up.
Thank you, Chair. I think you have already answered most of the questions that I wanted to answer. And the first, it was just to confirm that the duration of licensing for license for trading is not specified in the Act, and it's being left to the discretion of the energy regulator. And we take note of Ms. Massetti and Mr. Mkize's guidance that the license term must be substantiated, and will try to enhance that the submission. But basically, the issue is that in the absence of the specified duration of the license, we are looking at the exclusivity on the trading part. And the reason that was submitted by ESCOM was that, look, we don't have the methodology to actually design the wholesale tariff at the moment. So we need 2 to 5 years to be able to do that. So that was the exclusivity on the load side is limited. The other exclusivity on the load side, the reason why we also decide to limit it is that it will not even be able to supply all customers. Some customers or some municipal substations are connected at distribution level. So in those instances, we have got at least a technical reason to at least justify this exclusivity, because the Electricity Regulation Act also gives us that discretion on a justifiable reason. The exclusivity on the generation side, I just want to clarify that one we agreed with ESCOM, we determined when ESCOM got this buyer reassignment on 6 June, I think, because that was one of the sticking points that were preventing us from moving forward. When it got the buyer reassignment for all IPPs that are currently committed to ESCOM Holdings, it means ESCOM can go on and we can process those applications and say, okay, we have got a bilateral agreement with these generators and with the ESCOM generators, so we can do that. We can write it on the license without any risk to the energy regulator. But we are also saying, going forward, we cannot pronounce on those procurement programs that are still to happen, because the Act gives that discretion to the minister. So it doesn't prevent ESCOM. The minister can still say, okay, bid window 8, 9, 10, I still want NTC to be the buyer. So I think we are covered, and we also put it in the license conditions. Thank you, Chair. You had already answered most of the questions. So in the interest of time, I'll stop there. Thanks.
Thank you, Mr. Hore, for your response. Mr. Murati. By the way, Mr. Mkize, if I could cut off for a moment, please take over. Yeah, Mr. Murati.
Thank you, Chairperson. Good morning, and good morning, members. Chair, maybe I needed to touch on the issues that relates to this, the nature of trading that is being raised. To say it's an activity that in the during the Electricity Act, the 1987, the activity was being carried out as embedded in the licenses of both the generation, both the generation and transmission and distribution. But with the advent of the Electricity Regulation Act, those activities were now separated. And when the regulator is now seized with the consideration of a new license under the Electricity Regulation Act, it will be remiss and unlawful on the part of the regulator to issue a license that is the transmission license, but there will be a trading component in that license that the regulator ignores the provisions of the Electricity Regulation Act to say that has been an identifiable feature or activity that the law says the regulator should license. So the whole principle of the licensing departs from the regulator carrying out its mandate. It departs from the regulator carrying out the provisions of the law to enable and insulate the decision to be lawful. Otherwise, that would become the decision will be reviewable on the basis that the regulator has ignored the provisions of the law. The second issue, Chairperson, that I needed to touch on is this issue of exclusivity, that two issues comes to the fore. That when an application was made, the issue of of the application being made relating to exclusivity by the NTCSA. The challenge, that the premature nature of it, is that the law prohibits a licensee, and at the time, NTCSA, for the activity that they will be carrying out, was not licensed at the time. They were licensee for purposes of transmission. But for purposes of trading, NTCSA does not have a license until a decision is made. So the irregularity that the energy regulator could be faced with would be to decide on the exclusivity of this trading aspect when the law says a licensee. So NTCSA firstly needs to be a licensee to can deal with that, so that it will satisfy the provisions of Section 21(2) of the Electricity Regulation Act, wherein the regulator can approve the justifiable and identifiable differences to can have that exclusivity or the discriminatory practice. The other aspect is it's that to date the industry gets it's structured in a particular way that the other licensees, the distributors, like your municipalities, they buy their electricity from the ESCOM distribution, and this might be a platform wherein an opportunity might be missed for the industry to be restructured to enable and afford any other licensee to can approach the NTCSA. I believe that there are contractual arrangements that must be honored, and those contractual arrangements between municipalities and ESCOM distribution, they can be amended in a way that the law will enable. So I think for the regulator to pronounce on this issue, it is an issue of it's a contract law. It is not necessarily that the municipality cannot, until such time that there is a decision of the regulator to the effect. The last part, Chairperson, that I needed to touch on is the issue of the buyer in terms of the transferable of the agreements, in that the conclusion of the power purchase agreements, be it post the Section 34 process, it is not a requirement for license. It is not an exercise of that the regulator has been mandated to deal with. It is again a contractual arrangement between the IPPs, the ESCOM, and any other role player that is involved. That when there is such a consent between the parties within the frame of the contract law, that those contracts can be transferred to any other person that the parties so agree. The regulator cannot now say that the agreement is with this other person, therefore it cannot be ceded. If the PPAs or any other agreement to that effect has provisions that allows for ceding, the parties to those agreements can cede and notify the regulator of where the contracts are supposed to be regulated. As Chairperson, we are aware that the regulator, when these contracts come, the regulator notes the PPAs. It doesn't approve the PPAs. Finally, Chair, that just to close the aspect that the provisions of Section 34, it concludes the aspect and properly locates the powers of the function of the regulator to say, in the instance the regulator may facilitate. It's not the power that the regulator needs to approve. It's facilitating the conclusion of the agreements between the parties if so requested. Chairperson, I thank you.
Thank you, Mr. Mrati. I'm hoping I'm audible. I've lost power from my laptop. Has just died on me. Okay. I'm not sure if there are any further questions, members. We've dealt with this. I know it's an important issue, but I'm not sure if there are any further questions of clarity or any additions.
So that's why I guess the proposal that is before us that says, yes, there are concerns around exclusivity in terms of buying and selling of power now, not on the trading side, but only dealing with the trading. However, as a transitional arrangement, when all of these other things are being dealt with, let that license be granted with that level of exclusivity, but be limited because it is seen as a transitional arrangement. So hence the proposal, members. I'm not sure if there are any other questions. If not, members, I would then like us to then go to the decision that is sought from us, which is in respect of trading again, taking into account all of the conversations that have happened and in respect of trading. The decision that is sought is on paragraph 13. There is a recommendation that the ELS recommends to the energy regulator that it approves the national transmission license. It approves that the MTCSA be issued with a trading license with the conditions, and one of those conditions is that that is being proposed is that we do allow for some level of exclusivity in the manner that has been proposed, but limited to the period of 2 years. And then it also approves the reasons for decisions and all of the enhancements that need to come with that. Better explanation in terms of in respect of the question that have been asked by members. I don't know, members, if you'd be ready and willing to then go for a decision on that one on the basis of that. By show of hands, members, for us to recommend. I'm actually just running this for the first time on the phone, so I may not be able to see them. But yeah, I don't know if there are any further concerns, members. Can we make a decision, or do we still feel that we need to deliberate, or we take a different view? Madam Spear, your hand is up. Are you voting, ma'am?
Thank you, Chair. Thank you, Chair. For me, Chair, it's the 2 years. As you have alluded to the fact that the issue of exclusivity is still a concern. To say within the space of 2 years, what is the mitigation measure, or we have to say this matter will be resolved by then, with regards to the trading license and taking off this exclusivity. So for me, that is where the issue to say, then what after 2 years? What if it's not closed within the 2 years? Shouldn't we look at a longer period? And then once, for example, the 5 years, and then if it is resolved, and then they bring in a new application for amendment to a period of the initial one that they had of 15 years. Is that not the better approach, rather than sticking to the 2 years? Because we've seen with the changes in legislation, the bill, the time it takes. So is 2 years enough? That's where my issue is. Thank you, Chair.
Thank you, ma'am. So your proposal is 5 years, as was also proposed by Advocate Ziton. Mr. Pokola?
Thank you, Chair. I think for me, I was going to maybe go around what Mr. Bia has said, that maybe the reason you are not getting hands from other colleagues is that 5 years was put on the table. So, and maybe 5 years is the more appropriate one. Thanks
for the guidance, members. I was actually going to go for the second version, perhaps. That's why I should have started with the 2 years as was proposed, but there is a 5 years. So, members, if we then agree that there's a need for transition and we think that the transition may take up to 5 years and we're granting a 5 year, would that be could we recommend a 5 year period? I guess that would then be by show of hands. I see Mr. Mkiza, are you voting?
Yes, I'm voting. I'm supporting the 5 years with the understanding that we are going to also to explain it properly in terms of the enhancement of the reasons for decision. I take it that also it's going to go for language editing, like I see, like in 3.18, there is some incomplete sentences, etc. But that is going to be dealt with in that manner. And therefore, you will have a year, but substantiated such that if certain conditions precedent take place earlier, it could be even stopped earlier. Thank you.
Thank you, Mr. Mkhize. Okay, can I then open it up again? I saw 3 hands, and I also, Mr. Pukula had proposed. I saw Mr. Mkhize, Madam Sdia, Advocate Sitole, and Mr. Pukula, you had also indicated, I don't know, in terms of your concerns, because it's a trading license, perhaps you may not want to vote on this one, which is understandable.
I will not vote on this one, Mr. Mayor. Thank you.
Thank you, Mr. Pukula, which is understandable. Madam Maseti, would you be comfortable with the recommendation for 5 years? Oh, Madam Maseti had indicated she has a meeting, an urgent meeting that she may need to attend at 11 for 30 minutes. So I assume that she is no longer on the call, but she will join us again at 11:30. I also support. So we have 4. We've got 4 we've got 4 members that could vote out of 4 that are in support of the 5 years. Therefore, we have a decision then that will then recommend a trading license for 5 years. Thank you, members. It's been a difficult one coming, but thank you for your guidance, both at the workshops and all other meetings that we may have had on this one. And truly apologize for any of the delays that may have come with this. But they were all in good faith, trying to arrive at something that was workable. Thank you. Can we then step off this one and go to item number 10, Mr. Mavuso or Mr. Hore? This should be a simpler one, but over to you.
Thanks, Chair. I think that this one is very, very similar also, and that the only issue here that I would like to draw the members is that this activity that is being applied for here is being carried currently by the Eskom Holdings, and this license will basically, if it is approved, will allow this new instrument to actually take over the activity. And the aim is to, be active in the Southern African power pool, and in terms of the the contract, bilateral contract, based on month by month, week by week, and day by day type of markets. And when we had the public hearings, Chair, the presenters, all of them supported this application, except the main issue that SALGA keeps on coming up with, the fact that they would need to distributors have access to the transmission infrastructure too. And then number 5 is, Chair, there are issues that the members raised during all the interactions, and we have also dealt with them. I don't know if Spiro maybe can come in and just maybe add on what probably I've missed. Thanks very much.
Thank you, Mr. Komano.
Thank you, Chairperson. I think Mr. Mavuso has covered most of the issues that are in this application. The only thing that I can add is that for import and export, the NTC is going to use the transmission network, which is interconnected to our neighboring countries, and also that the energy that they are going to import and export, it's through bilateral agreements and through sub-participation. And Chairperson, the recommendations are on P10 of the submission. Thank you.
Mr. Hora, if you can add, please.
Yes, I just wanted also to highlight that on this trading, the other issue of exclusivity was also dealt with, but it was not recommended that it should be an exclusive import-export. Thanks.
Thank you, Mr. Hora. So members, there you have it. So on this particular one, the issue here, so maybe Mr. Hora, just to clarify, what you are saying is that it's not that other people will be prohibited from using the NTCSA network to do their own import and export if they're so applied and they were so considered and their license is so granted. Is that correct?
Yes, that's correct, Chair. And we, in considering that decision, we also took into consideration that the SEP rules allows other private entities to also import and export. And we also looked at the other benchmarks where, for example, in India, there are contracts that are similar to HTB, where the government enters into government-to-government agreements, where the minister or the government still have got a role to play in that capacity. But at the same time, there are also those other private players that can also import and export on a bilateral agreement. So we think these two can coexist. Thank you, Chair.
Thank you, Mr. Hore, for the clarification. I assume that is all contained in the RFT. Follow this articulation, Mr. Hore?
Yes, it is contained, but I want to declare that we might need to just enhance it because of the time pressures that were there. We concentrate more on the trading than this one, so there might be errors here and there, but we have been working on it since we submitted it. So there will be some enhancement. Thank you. Thank you.
Thank you. Members, you've got the item before us. If we can then engage with it, please. Any questions, comments on this one? By show of hands. Seems to be clear enough. Oh, Mr. Pokula.
Thank you, Chair. I don't have, I think where Mr. Hore has already said that this needs to be done. For instance, if you go to the main document 4.1, we still talk about that the trading license was, and there's a lot of other things that need to be just rectified because I think the copy and paste between these two licenses didn't help. So before we approve, can we just make sure that whenever we are talking about this one, we're talking about the import-export license? And the 20-year period, I think it's also in order. I don't have comments there. Thank you.
Thank you, Mr. Pokula. Advocate Tutolo.
Thank you, Chairperson, and thanks to the team for the presentation. Chair, I think mine as well, I think Mr. Pokula touched it a bit in terms of the 20-year term, in terms of the license. And I'm also asking myself, because if you look at the draft amendment bill, it talks about the national systems operator taking on the function of central purchasing, or rather, the function of central purchasing. And that particular structure is deemed to, or rather it's assumed that it will be formed within the next 5 years. So I just want to find out from the team why the 20-year license period. Did they take into account what is in the draft amendment bill? Because this bill, it's very much at an advanced stage and it can become an act as it is. And it talks about the national systems operator taking on this particular function of import and export within that particular period of 5 years. So if they can clarify the 20-year period listed under paragraph 3 on page 92 of the draft license conditions. Thanks, Chairperson.
Thank you, Madam Tutolo. Any other questions, comments, members? Mr. Pokula?
Thank you, Chair. There was an elegant suggestion by Mr. Mkhize that as much as we put the period, but we have something that also indicates that when there is a change necessitated by the change in law, or I think he had put it more elegant than I'm putting it, then we will reopen this and look at the term of the license. And I think I was hoping that this is also going to be transferred to that part of the decision as well.
Thank you again, Mr. Pukula, for that, because I guess it is understood that although we may be governed by the existing Electricity Regulation Act of 2006. But if it's amended and additional functions and other things change, that clearly it then changes and would necessitate that all of the existing licenses may need to be looked at. With all of the challenges that came with the introduction of the 2006 Act, from the 1987 Act, that there were changes that, although were supposed to have been implemented, have not necessarily been implemented. But the point is that if there are changes in law and they affect these licenses, what takes precedent is the law. So that is understood. Thank you for the reminder. But it needs to be explicit in the as conditions of license, Mr. Hore. But I think the issues of cut and paste, Mr. Hore, clearly we need to deal with. We need time to actually make sure that we only talk about aspects here in the import and export license that are peculiar to the import and export license. And remembering that the NTSA, in respect of its TSO operations, has already been given rights to import and export anyway. So we need to infuse those two. So as we finalize this, the RFD, please, colleagues, just make sure that you polish that up. That's as Mr. Pukula has indicated. But if we can then respond to the other questions, why 20 years?
Thank you, Chair. I think on the 20 years, we tried to align it with the NTC transmission license, and we also took into consideration that it becomes cheaper for NTC SA to sign long-term power purchase agreements than short-term power purchase agreement. And we also considered the bill, the draft bill, that it's being done. But as we were guided also by our principles, we didn't put much emphasis on the draft bill. We could only consider some of the things and mention what is likely to happen, but could not use the actual decision on the coming bill, because sometimes these bills, they don't materialize. But as Ms. Mkhize have already said, and as Mr. Pukula have alluded to, if there is change in law, then yes, this can be reopened. And I think as it is, the new bill will be more facilitating to include all these other things in a more clearer way. So we think if the new bill is approved, it won't be much of a problem to reopen it and amend the license. Thank you, Jen.
Thank you, Mr. Hore. Members, any further questions, comments? Noting that we still need to do a lot of rework on these documents. As I've indicated, the focus was more on trading and not on the import and export, and therefore there needs to be a further refinement of the wording and basically just a document before this document serves before ER. Any other questions, comments? If not, members, can I then take you to the decision that is requested of us, and that's covered in the overstem, starts on the overstem page, page number 10, and is paragraph 13, that we are requested to recommend to the ER to approve this license with all of the conditions that have been approved, with all of the changes, members, that needs to be, all of the both grammatical and other changes that need to be made to these documents. But members, can we vote on this? Can we recommend by show of hands? Okay, Mr. Pukula. Sorry, let me just see if I can see. Can I be assisted? I see Mr. Pukula. I see Madam Spear. I can't see the other colleagues. Advocate Tole.
Chair, we have Mr. Mkhize, we have Advocate Tole, we have 4 members.
Okay, thank you. And
you are the only one remaining.
I also support. Thank you. All right, thank you. I'm actually operating. I'm trying to run this. I've never done this from the phone, so I'm trying to run this. Maybe I'll just hand over to Mr. Mkhize to assist me henceforth to just facilitate this. Mr. Mkhize, can you assist me, please? I'm struggling with this, with running this from the phone. Can you take over from item 11, please, for me?
Thanks, Chairperson. I will just proceed then. Item 10 has been dealt with. Mr. Mavuso, may you please assist with item 11, which is a proposal for the adoption of the net billing framework for standardization of the net billing scheme among licenses. Over to you, Mr. Mavuso and your team.
Thank you, Chair. Chair, I just want to make maybe an intro comment on this one to say, because this the process that we have embarked on this one is new. It did also stretch us and also involved a lot of legal analysis. As such, I would like right at the end Boniseni to come in just to also give us some view from a legal point of view. So here this is a NICOM initiated project and the net billing, and that we have been asked to develop the rules. And Chair, we found really after final beating this, we found that actually we don't have the mandate on this one because number one, the net billing is not purchase of power, and that which is our preview. And instead, Chair, from our side, the conclusion that we have is that NERSA should instead approve the distributors to develop guideline rules and contractual terms and conditions for net billing within the area of supply. But I thought if you can come in just to maybe explain the process and where we started. Thank you very much.
Thank you, Chair. Just to give a briefing in terms of where we are, Mr. Mavuso has just outlined in terms of the background, but I'll just go through what the team has done. And also request that the submission, the ELS note the proposal of the proposed net billing framework developed by NICOM as Annexure A, and also the analysis that the team has done, and also that the ELS committee approve that distributors develop their own guidelines and rules on net billing. So in terms of the background, it's just a summary that it was developed by NICOM just to ease on the electricity crisis and also to assist in load shedding. And the request after development of the framework was sent to NERSA by the DMRE on the 27th of March for the adoption of the framework. And NERSA had a view to develop rules or either to amend the distribution code, of which the decision was taken that we can develop rules. And we went on to do a consultation paper that was published in April for stakeholders to comment and also to pass their views around net billing. And mostly the comments came positive, and especially from network owners like ESCOM and the municipalities. Then the next step, we needed to do an analysis as a team and prepare a aid memo for the ELS workshop, which was organized on the 26th of July. And members there raised various issues that we responded to, and also attached on Annexure B in terms of what we dealt with in terms of the issues they raised. And then we are given guidance also by members and to also do a further analysis, especially on the legal jurisdiction of NERSA to develop the rules. So we also received a legal opinion from the work stream that developed the framework under NICOM regarding what NERSA, if NERSA does not approve, develop the rules, what should happen. And they were opinion that ESCOM and municipalities and other distributors have a mandate to develop guidelines, bylaws in such case of municipalities, or contractual terms and conditions for net billing in their areas of supply. But again, the team did further analysis that also I will ask team members to assist me with in terms of what we have done. But maybe they can just give a short briefing in terms of the points that we have raised We dealt with the legal analysis under the LAS, under Mr. Murati. They will share with us what they have discovered. The analysis of net billing scheme in other countries, how it is being implemented. Dr. Kasheka will share with us in terms of that research. The analysis on the technical aspects of the framework, if we have to do the grid code, Mrs. Rakalakan will assist in that part, and also the impact of not having a legislation of implementing these rules. So then, in a nutshell, I'll come later just to finalize the submission. So for now, I can hand over to the legal analysis team of Mr. Murati. Thank you.
Thanks. I just loath of having a very long presentation. If you can just, everyone that is going to talk now, just be very brief and to the point and deal with all the issue that pertains to your area. Also from your side, Mr. Murati, if you may just explain also even the recommendation why you've got to approve something that the distributors already have as their right, and if we can't make a guideline instead of having rules or just like we do with matters that pertain to some kind of I would call it frequently asked questions in that mold. So if you can just talk quickly to this and our legal mandate in this regard. Mr. Right, over to you, sir.
Thank you, Chairperson, and once again, good morning to members. Chair, I think let me start by dealing with the last part that you have raised, to say one is very cautious to attempt to utilize the provisions of Section 35 of the Electricity Regulation Act. It is not a section of just a general application in its nature. It is premised on the provisions of the main act to highlight what is it that the energy regulator can do in terms of either developing a code, developing guideline, or developing rules. The premise of it is around the mandate. And with the proposition that has been made from the NECOM, the usage of that section would have generated a new mandate for the regulator using the Section 35, and such would have been an unlawful act on the basis that the powers to make delegated legislation does not render the administrator to have the capacity to expand on its scope. So there is that disjuncture that could have been created in terms of the regulator proceeding to deal with that. The second part of it, Chairperson, is that the Schedule 2 of the Electricity Regulation Act has properly outlined the location of which powers, who can exercise the powers, and with regard to the distributed these distributed generators, the provisions of the Schedule 2 has properly located that function as a mandate of the distributor. Outside of that, it defines the registrability or the licensability of those activities. So there is that disjuncture right from the onset on the issue of whether the regulator can generate rules or guideline, because one of the fundamentals is that it is pointless for the administrator to develop an instrument that it can't enforce because of the absence of jurisdiction on it. The second issue, Chairperson, that we have looked into was the aspect of segregating the framework into different parts, the technical and the financial side of it. The financial side of it, which is what Mr. Moreng has touched on in terms of that we are not dealing with a tariff. It is not a tariff, and the regulator has been mandated to regulate tariffs, and tariff has been so defined in the Electricity Regulation Act. So that aspect, we left it out and then left with the issue of the technical side to say the regulator has the powers to develop the technical requirements within the industry, and such It's located through the existing grid code advisory committee where the aspects goes through. So there is the technical aspects of the framework can be so catered within any of the instruments that can be developed through the process of the grid code advisory committee. The last part, Chairperson, which we looked into was to say this aspect of the licensees being able to deal with. We made reference to the current case that is being ventilated in court, that ESCOM is opposing the application by one of the participants to be able to connect to the system, to say they have the powers to define the entry requirements that must be met by such an applicant, to reflect that the regulator need not venture into that particular space unless the issues that are being dealt with are such that they may need to be referred to the regulator in terms of section 21.2 and 21.3, where the regulator maintaining the neutral arbiter, then it can deal with that particular issue. So we felt that in our conclusion, we made a recommendation to the team that this matter does not arise in terms of the mandate of the regulator. It needs to be left, and the technical aspects of it should be dealt with like all the other technical aspects that we have been dealing with for the industry. Thank you, Chair.
Thank you very much. Without any further ado, I think it would be proper that maybe members, if you've got any questions, comments, or guidance from your side, just by show of hands. Start with you, Mr. Pukula. Over to you, sir.
Thank you, Mr. Mkhize. Mr. Mkhize, some of us suffer from having this degree from the University of Nesa of Law, but with that limitation, I just want to find out from Mr. Murati that because out of these guidelines that would be created by the distributors, there will be charges that would emanate from that, and according to a certain section of the Act, I mean, licensees are not allowed to have any other charges other than those approved by the regulator. So my point is coming to the fact that even if they would develop whatever framework, because there will be charges that would emanate from that, there's an approval that must be done by the regulator. So in the designing of these rules, I am not sure if we can just say they can design the rules without putting the parameters that are required to be put in by a regulator, because even now, those that are registered by the regulator, by the way, they're not just registered by anyone else, they're registered by the regulator. There are some regulations, there are some conditions they have to meet for their registration, because registration is not just registration with nothing, it's registration with certain conditions, and one of them is you've got to meet the grid code. The second part of my question is around the fact that unless we don't recognize what is being issued by NICOM or what is being issued by whatever department as government policy, but there's a requirement that we must issue rules for implementation of government policy, unless what we are talking about is not recognized as that. And thirdly, I also think that as a regulator, we, before being asked to come in Section 21 or Section 22, when we are going to be arbitrating on things that we have allowed to develop without our intervention, I also think that in all of these entities, other than, yes, your technical requirements for connecting onto the system may come from the licensee, but we administer the grid code, which has exactly those things. And if it is deemed to be unfair or prejudicial to any other party, it can't be that the licensee will just decide on who will come in and who will not come in or will not connect onto the grid, and when they are going to be doing it with prejudice. So I am not sure if we are completely, I know that we locate our not being able to do this on that it's not entirely clear, or it's not entirely our business to deal with the registered entities. But I mean, they are registered by the regulator, not by anyone else. So I'm not sure if we should really not come up with really the boundaries of where these guidelines would be developed, and also have the part of saying that they have to be approved by the regulator, because I think the Act, that's what it says. But that's my contribution, Chairperson.
Thank you very much, Mr. Pukula. Mr. Komede?
Thank you, Chair. I was going to also add on this. Firstly, the issue that has been raised by Mr. Pukula about the approval of charges. I think I wanted to also locate this thing properly, colleagues, to say the challenge that we are facing is that as the regulator, we have no mandate over tariffs of anything that emerges from Section 9 of the Act of the registrants. So in the event that anything that pertains to tariffs of registrants, we have absolutely zero mandate on. And we've tried that before, even in terms of the PPAs that we tried to even note, and it was made clear, even by NICOM itself, to us that, Mr. Regulator, you have no right to even ask for those PPAs, and you have no right to even note. I'm not even talking about approve the tariffs between those in the tariffs that emerge from those processes. What's even worse is that with this group, or some of the people that are considered here prosumers, some of them are not even registered. So they don't even fall within the ambit of ERA. That was the challenge that we are facing. Now, the question that then arises is that if there is a purchase of power by our licensees, and therefore there are charges, as raised by Mr. Pukula, there are charges that then come out of this. How do we process those charges? So, for instance, when we're looking at tariffs for a distributor at the moment, we base most of it in terms of bulk purchases, as if all of that power was actually purchased from Eskom. And the Eskom tariff that they're using is an ERSA tariff that is approved by ourselves. And therefore, the starting point is that although the procurement itself was not done in terms of Section 217 of the Constitution, is that the tariff itself that at which they are buying actually is something that was approved by the energy regulator. Now, in respect of the people that firstly fall outside of ERA, and then secondly, those that fall within the realm of the registrants, where the energy regulator had no jurisdiction in terms of the tariffs, how do we take those into account? It's a problem that still needs to be solved, because it's a problem that we need to actually deal with in the future. Now, the issue of policy. Now, the challenge that we are facing with this particular one is that it is quite clear that the Act is very clear. Section 4 is very clear. It must be published national policy. Now, to the extent to which net billing would have gone to cabinet and there was a cabinet decision on it, that could be deemed to be national policy. But unfortunately, don't think that the NICOM pronouncements have the same level of authority as a cabinet decision. So the issue was, is it not possible for us to get an explicit policy announcement, even if something that comes from a cabinet minister, from cabinet, that indicates that this policy shall then be allowed. But then in that policy, the other issues that are key issues will then be considered. For instance, the one key issue that is of concern here is that when people export power, is that export time-based? Is that linked to time? Or is that value of power that is exported at 12, if it comes from PV, is it that same value the same as the value of the power that could have been exported or is then imported at 7 in the afternoon? Is that power, is that time-based? But if it's time-based, then you need to have a smart meter to be able to monitor that. to make sure that you can note the time at which the power was exported and note the time at which it was coming, that it was then brought back. That's number. Number two, you also have a key issue that says if you don't have an unbundled tariff, which is what Eskom had applied for, basically what they're saying, comparing a tariff of somebody exporting power from a PV system, their own rooftop, comparing that power that is exported and comparing that with an Eskom retail tariff is very unfortunate, because the Eskom retail tariff, we know what goes in there. There are capacity charges that are in there. There's also network charges. So that comparison is not fair. But, well, it's unfortunate. However, if there is a policy position that does that, having considered these issues and makes a pronouncement that the comparison should be at that level, it is then guided by policy. I think I will stop there, Chair. Thanks.
Thank you very much. I don't see any other hands. Mr. Pugula, over to you.
Apologies, Chair. I hate dragging a meeting, but I just wanted in the discussion or the proposal by, or the input by Mr. Murati, there's a part of the act that I didn't hear him mentioning, and this is the one around registration, and really the one that I think it's 10, if I'm using the right act, 10.4, says the regulator may make registration subject to adherence to the provisions of this act. So I don't know if these entities that we registered, we didn't make them subject to whatever provisions of this act, and one of them being that if they want to be selling power, if there are charges, I mean, there's a whole list there, and there's even the one that I like the most in that list of the areas where we can make conditions. It's set, it says, or any other condition that we may deem appropriate. And if you even look at 3B, it does say that we can't register things that would do things that are contrary to the objectives of this act. So I really would want to understand that in concluding what we had concluded, is there no other way in which we can insert ourselves, not because we don't have any work to do, but because we want to ensure orderly development, which is one of the objects of this act, of this industry, that we can find a way of ensuring that there's order in the way that net billing would be done. Thank you, Mr. Mkize.
Thank you very much, Mr. Pugula. I would then hand over to you, the Murat and the team to respond. But before then, there's something that I've requested for a long time now, and it has not come through. One of saying, let's go to the Act, look what are the provisions there, and make sure that we've fully implemented the Act, in other words. So when we look at that, it then talks to the issues that also Mr. Pugula has raised. To say, for example, is there any issue that we will be responsible for, or we're required to develop a rule or two, even if something goes to the Grid Code Advisory Committee, that there we can pull that and require that it be in place, because we need to make sure that whatever that needs to support what the industry would have developed is in place from our side. We don't get caught with our pants down when it comes to these issues. I think if we can just be able just to talk to that, because it's not necessary to say now let's deal with this in particular, but let us work on something around that. And then on the other hand, I think it's also going to be important to be clear as to what constitutes a policy, because what they have may not necessarily be policy. I would recall some years I had to look at policy. I had to publish a document to make sure that the document is properly classified as policy. And I think it's up to us to then advise NICOM or the policymaker to ensure that what they have falls within the scope of being classified as policy. So if we can just be able to look at that. And then the other issue that I've asked that it be clarified to me, then we can be able to move forward, is the recommendation to say we're approving that leg of the recommendation, to say, do we really have to approve something that is not within our purview, but it's actually what the distributors already have, and they can do that without necessarily us approving? Or we can just say we note that it is the distributors that have got to develop the net billing rules. I see your hand is up, Secretariat.
Thank you, Chair. In line with the communication I sent on the chat, I'm just surprised to ask members' indulgence to stay on and conclude the agenda, given that now we are at 12 o'clock sharp, which is the time that we're supposed to end our meeting. Thank you, Chair.
Thank you. Members, may we proceed with your indulgence? Thank you. All right, may you please respond? Timrati?
No, I've seen Mr. Bukula's hand was raised, but I can proceed.
Yeah.
Okay, let me address firstly the issue that Mr. Bukula has touched on, the provisions of Section 9(4) of the Electricity Regulation Act, which deals with the regulator making the registration subject to adherence to the provisions of the Act. Chair, the powers of the regulator are not a common law powers. They are statutory powers in nature. And as such, the interpretation of statutes explains that the first or the departure point of interpreting a statute is to give it its ordinary meaning, the words of it giving the ordinary meaning. And if I can invite the subcommittee chair to say at greater length the provisions of the Electricity Regulation Act specifically identifies a licensee. It's only in the proposed amendment that is going through Parliament that they've used licensee and registered. So for the regulator to rewrite the provisions of the Electricity Regulation Act so to fit into the reading of the Section 9(4), it will be improper because that is not how the legislature has defined the provisions of the law. And we were cautious, we thought of that, we were cautious of that. And the issue of the interpretation of statutes came to mind to say we should not mislead the energy regulator in terms of how to read the provisions of the Act. And one would also then touch on the aspect that when one looks at the revised schedule, the minister has gone to an extent of adding just the provision of the revocation of the registration. Though it is there already in the Electricity Regulation Act. I'm just trying to bring this aspect to show that even the minister is alive to the aspect that the greater content of the Electricity Regulation Act makes reference to a licensee and not a registrant. Chair, I also need to bring the members' attention to the provisions of Section 224 of the Schedule 2, which locates the issue, though that it worked on a threshold of the 100 kilowatts, that it locates the threshold of the distributor prescribes the conditions relating to the use of the point of connection. And the regulator can only prescribe how to keep that register. So the whole aspect of the terms and conditions have been in terms of the Electricity Regulation Act Schedule 2. It has been placed on the distributor. Those generators that are outside of the exemption to register or hold a license. Chair, I need to draw the attention of the attention of the members to the provisions of the new gen regulations that deals with the purchase of power by an organ of state. So in the event that therefore this aspect relates to a tariffing issue that needs to be paid by a licensee, the new gen regulations identifies that one, the minister may give an exemption to a licensee not to go through the procurement process. Otherwise, the default becomes that the issue of the purchase of power from any person, if it has to be regulated, it has to go through the new gen regulation. So what we have, Chairperson, as we highlighted, that the issue at hand is about a compensation mechanism that is between the licensee and the customer that is generating power. And if you look at the provisions of the framework, it provides that it's excess power that is supposed to be evacuated to the grid for consumption by this distributor. It is not about a generator that is established solely to supply the distributor. It's about an excess power that is not consumed by the customer at the time. But the primary purpose of such a facility is for consumption by the customer. So there is that distinction that the framework that has been given identifies with, and also the statutory side of it, that in the event it is on the other side, the law has created a passage of how is it supposed to be dealt with. The last aspect that that Mr. Bukula has raised, the issue of the Section 4 of the Electricity Regulation Act, that we need to be issuing rules for purposes for purpose of implementing a government policy. To date, we have inquired. This has not yet been made a government policy for purposes of the Section 4. It is still it's a communication that we have received from NICOM. It doesn't fit into the aspect where the regulator would say we're developing rules to implement the policy. We have looked at that aspect as well, Jay. Thank you, Chairperson.
Just on the two aspects, please. The recommendation in terms of us approving instead of noting.
Chair, I'm incapacitated to give a comment on the part that I would invite my fellow colleagues to come and make a comment. Mr. Shozi, to come and make a comment in terms of the recommendation. I'm incapacitated, Chair.
Would you be amenable to say you are going to peruse the Act in terms of what other supporting function we could be performing or doing regarding this net billing issue? What other things we need to do so that we've got all what is required of us in place?
For purposes of that, we can, as a matter arising, we can undertake to work with the team to relook at that and provide our commentary to that effect.
Okay, thank you. Maybe before someone comes in terms of the recommendation, Mr. Pukula, over to you, sir.
Mr. Mkhize, I would so want to say that as we look at this, rather than looking at how we are not going to do this, I think with the loopholes and the gaps and the inefficiencies of our policies because they didn't anticipate this, we can find a way of ensuring that we move the industry forward by leading this and finding ways of saying we are not far off, because nobody really is entitled to do these things. And I think that's the direction that can be helpful to the country, rather than the one of pulling ourselves out and saying we can't do this, and then there's nobody else to do it. Thank you.
Thank you very much. Advocate, just one thing before I proceed. Oh, Mr. Komede, just on the side.
Thank you, Chair. I
would like us to move to close this matter, please.
Yes. I would just like to actually just raise the issue, to comment on the issue that was raised by Mr. Bukula. That I think the delays that have come with the finalization of this framework was exactly that. That is, in us coming back and saying, well, clinically, do we have any jurisdiction in terms of registrants or non-registrants? The answer is no. Therefore, we should not even be looking at this. Is there a published national policy? The answer is no. Therefore, we should not have. We tried to then say, how can we best assist? That's where the delays have come. So I think what I would propose is that as part of our advocacy campaign, is that we look at things that we can do as part of our advocacy and to see what we can advise on. But then, as Mr. Mkhize, you've guided many times before, let's make a decision on the matters that are before us based on the information and the powers that we have. So I think that's the reason why it is here. And Mr. Mkhize, I would agree with you. I think we need to convert C into note and not into approvals. Thanks.
Thank you. Just the last one, Mr. Murati, please. On the issue that I raised, I did not get a clear-cut response. If we were to have a paper that we publish, say, for example, saying when looking at net billing, these are the issues one needs to consider. It becomes more like an advisory note instead of it being a rule or whatever. Will that help, or you think it's got no space?
Chair, as we highlighted and as I said earlier on, that we will go back and probably on the side of processing this issue to look at what you are raising and what Mr. Bukula has touched on, to see to the extent of influence that can be made and the direction. But for purposes of the law as it stands to date, we will be traversing a very uncharted waters, that we might be exposed to matters that, or end up having to deal with matters that we were not intending to. So we will look at the new scope of it to cover the issues that you are raising and the issues that Mr. Bukula has guided on.
Okay, thank you. Having noted the deliberations, members, the recommendation is for the legislative subcommittee to note the proposed net billing framework, and then to also note NERSA's analysis of the net billing framework, and lastly, to also note that distributors are the ones to develop guidelines, rules, or contractual terms and conditions for net billing within their area, their areas of responsibility, of supply, sorry. And then the added one is that to note that the team ELR is going to look at other supporting initiatives related to the net billing, so that we can play a leadership and a role in ensuring that this aspect is dealt with to the benefit of the country. That is what I'm putting forth. If you support that by show of hands. Thank you, Mr. Komede. Thank you, Madam Sbia. I'm not seeing other members. It's only the 3 that are supporting. From your side, Mr. Bugula and Madam Maseti?
Mr. Mkhize, I would support the first two. It's the third one where I'm not happy to support, because then we are going to have licenses that develop their own rules and have their own charges and have some unorderly development. So I would have wanted something that talks about for approval by the regulator. But as Mr. Murati has indicated that maybe we don't have this, but I'm still not convinced that we don't have the jurisdiction. So I would rather not approve the third recommendation.
The one of to note, that distributors are the ones with a mandate to guide, to develop.
Yes. Yes.
Okay.
Yeah.
Thank you.
Chairperson?
Yes, Madam Maseti?
Yes, Chairperson, I'm not comfortable from my side on that very same note, because we kind of allowing self-regulation. And as we do so with that third one, as we do so, we also do not put forward what may happen, to do the sort of a potential impact assessment for such price regulation, even to cover one of the possible concerns that are highlighted by Mr. Bugula. So it is important when we take a particular position as the regulator, as the decision of the energy regulator, we're quite aware what the likely impact is going to be in the industry if everyone now is doing this and doing that, and we don't have a way. So we rather not make it our decision and see how best we can come in and provide guidance on that issue. So that's why I am concerned and feel that I do not have the information to know what will happen when I kind of endorse self-regulation on that aspect.
Okay, Mr. Murati, if you can just come in, because we need now to be able to persuade one another so that you can be able to get alignment. Over to you.
Sure, thank you very much. And I think Mr. Moring, when he started, he outlined the frame, the core of the framework. What it does not venture into is to remove regulation of the distributor by the energy regulator. That part remains, and for any charges that the licensee will be imposing on any person will be the Section 15 of the Electricity Regulation Act will remain operational. The grid code will remain binding on the distributor to ensure that the activities that the distributor carries out or accepts are not in breach of those provisions. So the only aspect that the issue we are raising with is to say the regulator does not have the powers to approve a compensatory mechanism for the electrons that would have been evacuated by the customer to the distributor. That is the only part that the whole long submission is seeking to address, that the regulator does not have the powers to approve that compensatory mechanism, because the issue at hand is neither a price nor a tariff. It's a compensation mechanism. The remaining regulatory components of that that have been approved, they remain applicable. I thought I should just further clarify that part, probably that part in a nutshell.
Thank you, because I said that is just noting, because they already have this mandate, but you are saying that maybe adding the word that are not at variance with the Act or in contravention of the Act, would that assist Mr. Pupula?
Thank you, Mr. Mkhize. I think your suggestion that not at variance with the Act may assist, but I seem to recall, and maybe the regulator acted out of its mandate, but no one challenged that the city of Cape Town and a few other cities had started something with feed-in tariffs, and our basis of approving what they were proposing was that they will still be sustainable, and they will still be financially sustainable, and they will still be able to operate effectively and efficiently with the charges that they're having. And I think that that's not a call that's far from the regulator, because you're supposed to regulate and ensure that there's efficiency and effectiveness in the way that things are done. So this one of leaving it to the distributor to decide on charges, I'm not supporting, because they will develop those guidelines, and if we have nowhere to approve, they will implement the guidelines, and they will not be sustainable if the charges are too high. So that part, I think we would not have executed our mandate. Thank you.
Thanks. I would appreciate if I can have some wording to just to cover that. And I see that Advocate Tole wanted to say something. Over to you, Advocate, then I can.
Yes, Chair, just to assist, because I also had a challenge with 13C. Can we not say we approve that they develop the guidelines, rules, and terms and conditions for net billing within their area, subject to the regulator approving what they would have developed, so that we ensure consistency and just and also order within the ESI? That would be my proposal in terms of how we can rephrase that C to really try and meet members' contributions that have already been made. Thank you, Chairperson.
Thank you. I note that you note members the proposal. Mr. Kumede.
Chair, I was going to propose something different and say, why don't we just expunge a C? Maybe replace it with something that talks to us advocating on these changes that need to give effect to these things. Because Chair, this matter has been with us for so long. We have tried to actually massage it to give ourselves powers. But the truth of the matter is we have zero powers in respect of the tariffs that are not for licensees. The Act, Section 14, does not apply to registrants, no matter how much we try to do this. However, if there was a published government policy, which we can advocate for, proper government policy that can take into account all of the pros and the cons, because there are cons that might be very evident that have not been discussed. The impact of people that may be paying or being paid a tariff when it's supposed to be just be compensated for the energy component, but they're actually paid a tariff which is much higher. But there's nothing wrong with that if it is government policy. But the problem is that there are costs that when people get out and they don't pay for the other cost, the fixed cost, that they've got to be carried by somebody. There are implications for any of these policies. That's why it needs to be a policy. It needs to be thought through. There is nothing stopping government from coming up with a policy. So my request is, why don't we just expunge C, replace it with something that talks to us advocating properly for a well thought out national policy that does not just take account of those that can afford, but takes account of people that can't afford to actually put rooftops on their roof stacks.
Yes, Mr. Kumede, thank you very much for input. I've just got a challenge here, because my understanding is that we also want to be decisive to provide some kind of certainty. You are saying we need to expunge. We've discussed this matter, and the second option is that we approve that the distributors may develop guidelines, rules, or contract terms and conditions for net billing, right, for submission or to the regulator for consideration, like what Madam Masset has also put here, for compliance with ERA provision, which is the same what in essence what Advocate Tole has put forward. Are we amenable to that suggestion? Not necessarily to expunge it. I just would like to check with you. I don't know, maybe Advocate Story, want to add something to that before we move on, please?
Yes, Chairperson. Chair, I just wanted to say that if one looks at the current era, Section 35 does say the regulator may, in consultation with the licensee, municipality that regulate electricity, etc., develop guidelines and publish codes of conduct and practice or make rules by notice in the Gazette. So, Chairperson, for me, that provisions does allow us to consider this particular submission in the manner that we are trying to address it, particularly when it comes to 13C, to say we approve that the distributors develop the guidelines and rules and contractual terms and conditions, which, as I proposed, that will be subject to approval of the regulator, because the Act does give us those powers to do this. So I'm not sure, Chairperson, if there may be a position that we do not have these powers. From where I'm sitting, I think we do in terms of that Section 35, and it does clearly provide the processes to how this can be done. Thanks, Chair. I just wanted to highlight to you that there is a provision in ERA that says that this can be done. Thank you.
Thank you. We have dragged long, very long, but justifiably so. I would like us to close on this matter. So, Mr. Kumete, the last take, then we can go to voting.
Thanks, Chair. I'm just going to respond to your direct question. Is that we could do that, but it's no different from what has been asked of us, because the framework has already been developed. Cape Town is already implementing something, and they're saying basically they already have the guideline. But the question is, if we approve something, we must, unfortunately, and this has been tested by, and Mr. Murati has indicated, and has been tested by other opinions, that we can't use Section 35 to actually give ourselves powers that we don't have. Whatever that those sections under Section 35 are guarding are issues that we've been empowered to do by the main Act, and therefore we actually give effect to that. But if we have no mandate in terms of the law on something, we cannot invoke Section 35 to actually give ourselves powers to actually write something. So even if we write something, those guidelines are written. If they are brought back to us to approve, we must approve something on the basis of the powers that we have. Otherwise, if we can't approve what is already presented here today, why write something that people are going to bring back exactly the same document? Because the frameworks are already there. The guidelines are already there that the people, why don't we just approve those if we believe we actually have the powers? I rest my case, Chair, and I'm going to stop there. Thanks.
Thank you, Mr. Pukula.
Chair, I do want you to conclude on this matter, but I think that we have dealt with the other parts, but the section that I read out that says that the regulator may, when making the registration, have certain things that it has for adherence to this Act. We have a door where if we haven't registered them that way, then going forward we must register these entities that need to be registered in that way. That enables us to do this. But I am happy to note the first two, and in the third part, I'm of the view that we can use the two suggestions, I think, by Ms. Masetti, but if then we are seen as not being able to make any pronouncements on things that we don't have powers to do, which I still argue that other section I read gives us the powers, then I would opt that we just leave out this part about us, because they don't need our permission anyway to develop these rules if we have no jurisdiction over them. So why even make a decision? Thank you, Chair.
Thank you. Just by show of hands, members, if you support that recommendation C be expunged, by show of hands. One, two, three, 4. Thank you. It then carries. So we note that the electricity subcommittee notes the proposed net billing framework, also notes NERSA's analysis of the net billing framework. C also notes that the team is going to consider other measures to support any guidelines, rules, and contractual terms and conditions that that pertain to net billing in the interest of in public in interest of the public. I think if you can just put it like that, you'll find the wording, Secretariat, if you can assist in that regard. That then concludes this matter, and may we please put timelines there, Mr. Murat and the team, to ensure that that action item is executed speedily. Okay, thank you. We conclude then item 11. Let's go to item 12.
Thank you, Chair. Chair, before I introduce the topic, I just want to apologize by some of the phrases that we have used in this report, where, for example, we refer to things like first half of this year. I think these are not legal terms. We need to change them. There's a couple of them there with that reference. Chair, and also just to say, in terms of the submission, this is a submission that is reporting back to the ELS in terms of the performance of the renewable energy projects in South Africa. I think, Chair, in terms of your own interaction on this matter, we have raised a couple of issues in terms of the empowerment side of things. And the report, Chair, in the main, which will be presented by Andile, does say the programs that we have in terms of these projects have actually exceeded their expectations in terms of not expectations but obligations from employment, ownership, and then procurement. And but from my side, Chair, I think we still need to do more work on this report. For example, it is not very clear to me in terms of these programs' contribution to deal with load shedding. Maybe we need more technical sections there to gauge this. And the third thing that, from just on top of my head, Chair, that I'm thinking about is the whole issue of from licensing these projects and when do they actually come into commercial operation. It's an important issue, Chair, as we deal with load shedding in South Africa. But with those words, I'll give it to Andile just to address the report. Thank you very much.
Thank you. Andile, just take the matter as read, which is a report on the performance of the renewable energy power plants for January to June 2023. Over to you. Take the matter as read.
Thank you, Chair. I'm going to do just that. The report really covers the capacity performance, and also does cover the costs. And as Mr. Mavuso has indicated, it does go into the contribution of on socioeconomic development by these projects. But in terms of the impact on load shedding, Chair, we did try to cover that. But as we know, these are intermittent projects at this stage, because we haven't got too much of the storage deployment. So, but there is an impact in terms of the reduction in terms of demand. If one looks at the hour to hour, especially during the day, that is when, for instance, the air conditioning systems are being used. But obviously this would become, these projects would have more impact later on when we have storages and so on. Without wasting time, Chair, I'm going to take members to page 4 of the submission, cover submission. And our recommendation, Chair, is that the ELS notes the report on the monitoring of performance of renewable energy power plants. This is issue 22 attached as Appendix A. And Chair, this will be published on the website when it has been edited. Thank you. Chair, I'm going to hand back to you.
Thanks, Mr. Klashek. I was talking on a muted mic, sorry. Any questions, comments, guidance members? I see none. By show of hands, members, if you can just indicate then if you support the recommendation that the electricity subcommittee notes the report of the monitoring of renewable energy performance of power plants, issue number 22, which is attached as Appendix A. Thank you, Madam Sbia. Thank you, Madam Assetti. Thank you, Mr. Pugula. Thank you, Advocate Tole. Mr. Kumete, I also support. This then concludes item 12. We proceed to item 13, which is a progress report on ESCOM transmissions corrective action plans in terms of the audit findings of the electricity transmission industry compliance audits conducted via desktop analysis in the 2022-23 financial year. Over to you, Mr. Mavus and the team. Take the matter as read, please.
Thanks, Chair. Chair, I think with your permission, can you just allow me on this one not to do the next four, including this one, just to pinpoint who is going to present, and this one will be done in the following one by Zuzek. Zuzek, can you please come in?
Thank you, Chair. Firstly, I would like to request that we omit the phrase via desktop analysis as it speaks only to the corrective action plan, not the whole thing. My apologies for that, Chair. This is a progress report for the audits that we conducted in 2022-23 financial year. We conducted audits on 16 substations transmission. And the report was noted, consolidated report was noted on the 30th of January, and it was shared with ESCOM. And then we sent them a template to complete the corrective action plan, of which they did, and they brought it to us. This is the template and that we want us to note at this moment. The only issue we had when we were reading the templates that the ESCOM completed, it was regarding the substation asbestos trench cover project plan, which they gave us that it will take them 7 years, that they will attend to that matter in 2030 as per their plan to change asbestos in all their substations. So we were concerned that they actually did not provide us with a plan of the specific substation, that which year actually it is for that substation. And also with regards to their gas analyzers, some gas analyzers were off in some of the substation next to the transformers. So they did tell us that they will do that in 2 years to come. Some they say 2023, which is around June this year, and others next year, 2024. So we were concerned too by that, because the gas analyzers are there to monitor the gas levels in those transformers. So then that means that the licensee has to devise other means to monitor the gas to avoid mishaps. With that being said, I would like to request the Electricity Subcommittee to note the progress report on the corrective action plans for audit conducted on the electricity transmission industry in 2022-23, and the appendix with the summary of those findings as well as the corrective action plans from ESCOM is attached. Thank you, Chair.
Thank you very much, Madam Jogo. Any questions, comments, guidance from the members, please, by show of hands? I see no hands.
Sorry, Chair, one small issue.
Oh, you may proceed, ma'am.
Thank you, Chair. Just one small issue. I noticed that we have some, thanks to the presenter for the presentation, some of them, the corrective action dates have already passed. I assume that it's still not complete, or the verification has not yet happened. What are the implications where it's still not done and they have not come to us for extension? What sort of mitigations do we have for such issues? Thank you.
Thank you very much, Madam Sbia. Your response? I don't see any other hands. If you may just please respond to that, Madam Jogo.
Thank you, Chair. With the ones that have passed, that means they have done those already. And what we do on a yearly basis, we do ask them that to write back to us annually to note all those that have already been done, that their dates have lapsed towards the end of the year. So they do tell us that, okay, this one and this one has been completed, so we can update our records. And again, we will also note that when we request a final report from them, when we are doing our closing report for the substations that were audited this financial year. Thank you, ma'am.
Please do indicate that in the report itself. So it is not an issue that is totally unattended to. All right, with that, members, by show of hands, I would just like to see if you support the recommendation that the Electricity Subcommittee notes the progress report on the corrective action plans for audits conducted via desktop analysis on the electricity transmission industry in the 2022-23 financial year. Thank you, Advocate Chole, Mr. Pugula, Madam Sbia, Madam Maseti. I take it, Mr. Kumeda, you had a challenge with raising the hand. You support, okay. I also support. So then this concludes item 13. Item 14, if you may just please also take the matter as read when presenting it. It is a transmission audit submission for the second quarter of 2023 with consolidated report for the compliance audits conducted on ESCOM main transmission substations. I don't know whether it's still yourself, Madam Joke.
Yes. Yes, it's still herself.
Thank you, Chair. This is the submission, which is a consolidated report for the second quarter of this financial year for the audits that we have conducted. We've combined the new audits as well as the re-audits. We've conducted 7 new audits, 3 re-audits. We've committed for our annual target that we will do 35% of our annual target this year, of which that was done. And these findings, the reports, the individual report were shared with the licensee, and the licensee have gotten back to us and told us that they accept the findings. And later stage now, we will send them the letter requesting them to do the corrective action plan on those findings that we have seen on the substations. We therefore recommend that the Electricity Subcommittee note the attached consolidated report that is outlining all the substations that were audited this financial year, which is the 7 and the 3 re-audits. Thank you, Chair.
Thank you very much. Members, any questions, comments, guidance on this submission? I see none. With that, I just go to the recommendation, which is on page 405, the black paging, and then the green is still 4. Says the Electricity Subcommittee is requested to note the consolidated report, which is Appendix A of this submission. By show of hands, members, if you support the noting. Thank you, Mr. Pugula, Madam Maseti, Mr. Kumede, Advocate Chole, Madam Sbia. I also support the noting. We then proceed to item 15, which is the progress report on the monitoring of the implementation of electricity distributors' corrective action plans in the second quarter of the 2023-24 financial year.
Chair, this one will be taken by Bulelwa and also Maya.
Okay, thank you, Chair. This is my Kobushian. The purpose of this submission is to request the Electricity Subcommittee to note that progress reports on the monitoring of the implementation of the electricity distribution corrective action plan conducted in the second quarter of the 2023-24 financial year. The Electricity Subcommittee is duly delegated as per section 31 and 32 of the electricity delegation matrix. During the second quarter, the distribution compliance audit team have conducted 4 monitoring on the 4 licensees. Going to page 4, it is then I then recommend. It is recommendation in this recommendation that the Electricity Subcommittee is required to note the progress reports on the monitoring of the implementation of the electricity distributors corrective action plan conducted in the second quarter of the 2023-24. Thank you, Chair.
Thank you very much, Mr. Koboshian. Any questions, comments, guidance from the members? By show of hands, please. I see none. I take it that members are content with what is in the report. The recommendation is for the electricity subcommittee to note the progress report on the monitoring of the implementation of the electricity distributors' corrective action plans in the second quarter of 2023-24 financial year, which is attached as Appendix 1 to the submission. By show of hands, members, if you support the noting. Thank you, Madam Maseti, Mr. Pukula, Mr. Kumete, Madam Sbia, Advocate Chole. I also support. This then concludes item 15, taking us to item 16. If you may just assist us, Mr. Mavuso, as to who's going to present item 16.
Phil Maipo and Mulel. Thanks.
Good morning, members, management, and colleagues. Thank you for this opportunity. The purpose of this report, similar to the last three that were just done now, is to request the committee to note the report, which is entitled Second Quarter Report on the Findings of the Electricity Distribution Industry Compliance Audits. So this time around, I will not go through the process of conducting these audits and monitoring thereof. But I just want to mention that we are aligned to the new APP, which requests that, unlike in the previous year, we do quarterly reports and we have increased the number of our audits. So in the previous quarter, in July this year, we presented our first quarter, which was noted, and there were 3 consolidated reports that were consolidated into one. So this quarter, we have consolidated 7 individual reports, which is quite an improvement from what we did during the first quarter. The summary of the key findings are in page 16. Yes, so we kindly request that this report is noted. Thank you.
Thank you. This is the last item in the open meeting. We'll then review our time contract once we're done with it. We'd just like to then draw you to the recommendation, members, which is that the electricity subcommittee notes the report on the findings of the electricity distribution industry compliance audits conducted in the second quarter of the 2023-24 financial year, attached as Appendix 1. Any questions? Madam Marcel, I'm not so sure the lingering hand or it's a new. Oh, I take it that's a lingering hand. I don't see any other hands. With that, as I've already read out to you the recommendation, members, by show of hands, if you are happy to note this report. Thank you, Mr. Kumete. Thank you, Mr. Pukula, Madam Maseti, Madam Sbia, Advocate Chole. I also support. This then concludes the item 16 and all the items that are part of what constitute our open meeting. With that, I would like to thank all the members of the public that joined us via our different live streaming platforms. And we appreciate your interest in the matters being deliberated upon by this electricity subcommittee of the energy regulator of South Africa. This then concludes the part of the meeting, and the open part of the meeting stands adjourned.